Good morning to everyone, and welcome to this webinar on the EU-Brazil conference on AI governance and regulation. My name is Luca Belli. I'm professor at FGV Law School, where I coordinate the Center for Technology and Society, and I will have the pleasure to moderate this webinar together with my friend Luigi Gambardella, president of EU-Brazil Business Association. Today, we have a very large number of highly qualified speakers. So let me quickly run through the entire panel setup. We will start, of course, with my friend Luigi, and then Maia Buzdugan, the Counselor for Digital Market at the Delegation of the European Union to Brazil. Welcome, Maia. Then Miriam Wimmer, who is Directress at the ANPD, the Brazilian Data Protection Authority. Warm welcome to you, Miriam. And then Juha Eikila, who is International Advisor for Artificial Intelligence at the European Commission. Welcome, Juha. Then we'll follow up with Laura Schertel Mendes, who is professor at IDP and directress of CEDIS at the Brazilian Institute of Public Law. And she was also the rapporteur of the Senate Commission of Juries that just released a report on AI regulatory framework for Brazil. Then we will follow up with Andrea Renda, professor at the European University Institute and researcher at CEPS. And then Eduardo Magrani, who is professor at Universidade Católica Portuguesa Law School, an affiliate at Harvard, and one of our visiting professors here at CTS FGV. Then we will follow up with Nina Daura, who is researcher at CTS FGV, where she leads with AI and cybersecurity and AI discrimination. And then last, but of course not least, Claudio Villar, who is head of product, data science and supply at Posterward Group. Now, before we start, two quick things. First, our usual disclaimer. So you already all know that all the participants here are participating to this webinar without having been forced by anyone on their own willingness. And then, of course, all the statements that will be shared during the webinar do not represent any official opinion of FGV, but it's only personal opinion of the participants. And that was our first institutional disclaimer that most of us already know here. And then a quick word of introduction, because it's very interesting and very important for the success of today's discussion to understand why we have been organizing this panel and what are the key questions that we aim at answering today, or at least providing some food for thoughts, so that both the participants and people who are following us from home can understand a little bit better the dynamics of AI governance and regulation in these two very large areas, the European Union and Brazil. So on the one hand, we all know already that we are witnessing the emergence of a very large number of AI systems, increasingly adopted both by the public and private sector for a very large number of uses, reducing the need of human intervention on the one hand, but also creating different needs for human intervention. On the other hand, we have some remarkable advancements in automation with very performing and efficient systems, which are also at the same time remarkably opaque. So this really leads us to ponder the necessity of AI regulation and proper governance systems. So both in terms of governance, participation of the various stakeholders that are affected by AI, and regulation, so the result of such interactions in terms of regulatory tools that can be actionable is pretty urgent. We had a very interesting conference at FGV 6 months ago, CPDP Latam, the Latin American edition of CPDP that last year was dedicated to AI and data protection. And what emerged from these 2 days of conference and all the publications we released only some months ago is precisely the need to consider very carefully how to regulate AI and the enormous synergy interaction that exists already between AI governance and data protection. AI is based on the processing of very large data sets, which also include a lot of personal data. And most of the 150 countries that already have adopted data protection laws, both in Europe and Brazil, but many other countries in the world, already have some tools that are very useful to tackle AI, including transparency, security obligations, a lot of rights for the data subjects that they are also rights of the individuals affected by AI, right? So we don't need, on the one hand, we do not need to reinvent the wheel. We need to implement what already exists. But on the other hand, data protection is by far not the only concern we have with regard to AI. The way in which an AI system control a turbine or an automatic vehicle has frequently nothing to deal with personal data, or how an AI application can perform a correct diagnosis of a cancer frequently has nothing to deal with data protection. So there are a lot of other dimensions that we should include into our discussion. And today's discussion is precisely about how Brazil and the EU are shaping their own answers to this pressing need. There are also some quintessentially regulatory questions that we should ask, meaning having a law and an authority is the only way, is the best possible way we can have to regulate a phenomenon as complex as AI. Again, data protection is very interesting as an experience, especially in Brazil, where it's very recent, not as Europe, where it's more consolidated, because it allows us to understand that new complicated laws require a lot, an enormous effort to be correctly implemented. And we may be willing to explore also alternative vectors of regulations, like pedagogy and an incentive, even economic incentive to regulation, because the traditional tools we have, simply creating a law and an authority, they are vital, they are essential, but they may not be enough to create this bridge between the legislator and the developer, the legislator and the user. Most people around the world in the 150 countries that have data protection frameworks are totally unaware of their rights. And most entities, they don't know how to comply well, at least. So it's essential that we also take this consideration when we speak about something as impactful and as complex as AI. Now, with this injection of optimism, I would like to start opening the floor. First, I would like to give the floor very quickly to my friend Luigi for some initial words of introduction, and then we can enter into the core of the discussion with our first speaker, Maria. Please, Luigi, the floor is yours.
Luca, thanks, and thanks also to Fundación Getúlio Vargas and all the participants. I just would like to say a few words, because I think what is important is to listen our speakers, and I'm sure that the debate and discussion will be very, very interesting. When I was discussing with Luca over the weekend the preparation of this webinar, I said we are very lucky because this happened after ChatGPT. I see before ChatGPT, after ChatGPT. Now we start the public opinion, but also many people who are have experience start to understand the opportunity, the importance, and the potentiality of artificial intelligence. Let's be honest. Before the discussion, artificial intelligence was only between some experts, but the public opinion was not understanding what really means in practice, the practical term, the impact and the potentiality of artificial intelligence. So this is the first point that I would like to underline. The second point is our focus will mainly be when we discuss about Europe and Brazil on trade agreement. And we saw what's happened with what is happening, and we hope that at the end something will be done with EU-Mercosur. But what we have to understand today, that non-trade barriers are maybe even more important than the trade agreement. So we attach a great importance, I think all of us, we should attach a great importance like artificial intelligence, digital, quantum, blockchain, metaverse, cooperation between Europe and Brazil. I think that this cooperation could go faster, does not require to be approved by the parliament, does not require all the mechanisms that have to be followed when there's a trade agreement, but are extremely important and can change the business relation, the relation between Europe and Brazil. And also this is important because we like to work on the future. And this is something, work on the past is something that is just the history, but we have always be focused on the future. And try to, and that's the reason why we are organizing this webinar, is help to understand what is happening in Europe, what is happening in Brazil, what are the best practices. We should learn. There is nobody who can teach the other. We should learn and understand. And also what Europe and Brazil can do, should do together in the digital area. For example, one element that we have to take into account that we were looking to European company AI, is not easy to find them. And imagine for Brazil is the same. So we miss, and we should have a discussion, maybe not in this webinar, but in this relation, how we can increase the number of companies in Europe and in Brazil, which will focus on artificial intelligence. Last thing, before I pass the floor to the first speaker, today I think EU and India just launched, finally, the Trade and Technological Council, which will focus on digital governance, connectivity, and green tech. And maybe that's just an idea that I put on the table. Brazil and EU should create as well a technological council in order to increase the exchange, increase the opportunity of discussion, because we see in this world how is important a better understanding, a better comprehension of the differences. Now, let me immediately pass the floor to Maria Dugan. She is Counselor for Digital Market Delegation of the European Union to Brazil. So she has a very important job. And I think that she should, in her initial remark, explain what's the ongoing AI regulation effort in EU, and as well as joint AI research opportunities and upcoming joint AI initiatives. Maria, the floor is for you, and thank you to be with us today.
Thank you so much, Luigi. Good afternoon, ladies and gentlemen. I hope you can hear me all right. I would like to thank Professor Belli for the invitation to participate today at this very important debate. I also would like to convey, on behalf of the EU Ambassador to Brazil, Ignacio Ibanez, his congratulations to Fundação Getúlio Vargas for the initiative to organize this Brazil-EU exchange on a fascinating and timely topic such as artificial intelligence and its governance and regulation. It is timely because, as mentioned here, both the EU and Brazil are elaborating legislative proposals regulating the development and use of the AI. And I think we can all agree that this is a fascinating topic. ChatGPT, was mentioned. During the winter break, I was playing with the OpenAI.com application, and I have to say that this really is exciting and at the same time scary, with the possibility it opens, but also the concern it raises. Just before putting down a few ideas for the discourse, I asked in the playground of OpenAI for a poem on artificial intelligence. And if you allow me, I will just read a few verses that artificial intelligence produced. We are all so afraid of AI as its power can be so great. It can think and make decisions that no human can replicate. But even with all its power, AI should not be feared. We should use it wisely and keep it under our steer. So AI on AI, I thought, the poetic talents are to be discussed, but I think there are interesting potential. Also on this, I mean, really, it's fascinating. On OpenAI, you can ask for almost any type of written product, from a speech on artificial intelligence and its regulation in the EU, which I may or may have not used for today's purposes. You can always also ask for a briefing on the latest developments in the telecommunication sectors in Brazil, or to draft an email to the Brazilian Ministry of Foreign Affairs asking for a high-level dialogue in the most elegant Portuguese. In other words, it can do the majority of the tasks of a counselor at the EU delegation, and it can do it faster and in some instances, I'm sure, better. Other than the justifiable concern that this tool can soon make my job disappear, which, by the way, could be an interesting topic for our next workshop, Professor Belli, one can understand the concerns that are raised by the question of trustworthiness of the product. AI is only as good as the data is using. So what if the data is wrong, incomplete, or biased? The question of trust is, of course, even more pertinent when I have to decide whether to trust the AI with an important health decision or when I am getting into a self-driving car. Also, another issue is the responsible use of AI. How will professors know that a student didn't get a beautifully written essay from an AI platform, or the lyrics of a Grammy-awarded song didn't come from the same source? Also, just to mention that OpenAI announced that very soon they will provide access to sound and video product as well. So how can we trust AI, and how can we trust ourselves with the use of AI? Many have realized these risks with the development and use of AI, such as certain characteristics related to the opacity of algorithms or the level of autonomy it brings. And this, as mentioned, poses a new specific risk to fundamental rights, including privacy, but also risks of discrimination and attacks to human dignity. For this very reason, specific measures, including legislative initiatives, are being discussed in the EU, in Brazil, and in many other countries. The European approach promotes artificial intelligence that is human-centric, sustainable, secure, inclusive, and trustworthy. The European Commission has the twin objective of creating an ecosystem of excellence and an ecosystem of trust to promote the development and uptake of AI while addressing the risks associated with certain uses of this technology. To date, the European Union has adopted an AI strategy in April 2018, a coordinated plan on AI with the EU member states in December 2018, and this plan was reviewed in 2021. A human-centric AI communication in April 2019, and a white paper on AI in February 2020. More recently, the EU is working on a legal framework on AI, and on this topic, I am very thrilled that we are here with a top expert from the European Commission, Juha Heikkilä, joining us in the second panel to provide us more details regarding this legislative initiative. For my part, I would very briefly mention that there are four key policy objectives for AI in Europe. One is to set enabling conditions for AI development and uptake in the EU, both from a policy point of view and also in what regards critical computing capacity. Second objective is to bring excellence from lab to the market and make the European Union the right place to do so. And this includes funding and scaling of innovative ideas. The third objective is to ensure that AI technologies work for people, and the focus is on talent and skills and designing a policy framework to ensure trust in AI systems. The fourth objective is to build strategic leadership in key sectors, and some of these key sectors are climate and environment, health, public sector, law enforcement, mobility, and agriculture. More specifically, to create an ecosystem of excellence, the Commission uses the Horizon Europe and Digital Europe EU-funded programs to support initiatives focusing, among others, on basic and applied AI, research, skills, uptake, and investment. There is a significant investment in research and innovation because we consider AI as a key enabler for R&I. AI plays a predominant role in the digital industry and space cluster of Horizon Europe, but also features in other parts of Horizon Europe program, for example, health, culture, society, climate clusters. And Horizon Europe will support research towards the next level of intelligence and autonomy of AI-based systems, transparency and AI, greener AI, and biased AI systems, among others. Just to mention that Horizon Europe is open not only to EU researchers and EU research institutions, but also to third countries researchers and institutions, as long as they are finding European partners and applying in this type of consortium. Also, I would like to mention that there is a new public-private partnership on AI, data, and robotics, which was set up in June 2021, which is expected to leverage 1.3 billion euros of public investment, complemented by 1.3 billion euros of private investment by 2030. And the idea is to address key challenges in European AI, data, and robotics. Also, another action is to strengthen AI research excellence centers to join forces and tackle major scientific and technological challenges in AI. And we also want to scale up the European AI on-demand platforms and become the reference European market for AI resources, developing a central AI toolbox for Europe for anyone looking for AI expertise, technology, services, and software. Last but not least, we are setting up AI testing and experimentation facilities to test state-of-the-art technologies in 4 high-impact sectors, namely manufacturing, health, agriculture, and smart cities. And there are also AI-focused digital innovation hubs with regional one-stop shops that help companies interested to use AI to become more competitive by using AI technologies. So there were only a few of the EU-funded activities regarding AI. Overall, the Commission invests about 1 billion euros per year in artificial intelligence, and the goal is to reach a total investment volume of 20 billion euros for both private and public sources by 2030. A few words on EU-Brazil cooperation on artificial intelligence. The EU-Brazil high-level dialogue on information society and digital economy, which is the forum that defines the priorities of the bilateral cooperation on information and communication technologies and digital transformation, has consistently identified the AI as one key area of common interest. At the 11th high-level dialogue held in November 2019, the last one,
it looks as we have some technical problem with Maria's connection. We will as soon as she will reconnect, we will give her a couple of minutes to finish her presentation. But I think in the interest of time, maybe we can start moving forward to the next panelist. So Miriam Wimmer, Directress of the ANPD, the Brazilian Data Protection Authority. And actually, it's good to have her today, particularly good, also in light of the previous statements about how the adoption of chatbots like OpenAI's ChatGPT is going to disrupt our work on one hand, but also data protection, if you want. I was also playing maybe in a more geeky way than Maria over the weekend with ChatGPT, and actually something that I tried to do was to test how they were at OpenAI considering the right to be forgotten. So I asked them if they could give me all the information about Mario Costeja Gonzalez, the initiator of the Google Spain case that led to the right to be forgotten. And the initial reply was that he was the initiator of this case and he wanted some information about himself deleted. And I was like, well, so what are this information? And what is this information? And then he provided, I'm humanizing the chatbot, but so the chatbot provided the information about the real estate. And so I was like, but aren't you prohibited from sharing this information? And the chatbot replied, well, not only, this applies only to search engines. And I replied to him, no, you are lying. You're a liar. Then at this point, I started playing with other trivialities on ChatGPT. But actually, this really brings us some very relevant questions, because again, we may argue that the initiator of the Google Spain case, Mario Costeja Gonzalez, achieved this kind of status of public figure. But if you ask detailed information about any other random individual that left tracks around the internet until 2021, so that is the database that is used to train ChatGPT, you will find them. You will find this information. That is personal information in many cases, or may even be incorrect because the automated processing language model on which ChatGPT is based is not always correct, right? So there are a lot of important questions we should ask, of course, not only about data protection, but mainly about data protection, about the most recent developments. And it's excellent to have here with us Miriam Wimmer today. So Miriam, please, the floor is yours to go ahead with your introductory remarks.
Thank you very much, Professor Luca. Thank you very much, Luigi, for the invitation to take part in this very interesting panel. As you mentioned, Luca, I currently work as one of the commissioners at the National Data Protection Authority, and I was also a member of one of the group of legal experts created by the Brazilian Senate to propose draft legislation on artificial intelligence, alongside with Professor Laura Schertel, who is also here today. So in fact, it's a great pleasure to join this conversation, and I really look forward to listening to the different perspectives. And in particular, I was asked to bring some opening remarks on the intersection between AI and data protection, speaking a bit about the existing Brazilian framework and the challenges ahead. And as I was preparing this small talk, I didn't use ChatGPT, maybe I should have, but I was in fact thinking about the many commonalities between Europe and Brazil with regard to this discussion. So both Brazil and Europe have AI strategies with different initiatives in the field of research, development, and innovation. Both are discussing the approval of comprehensive legislation to regulate the use of AI, and both also possess comprehensive data protection laws based on certain common elements. And here I'd like to highlight the recognition of a fundamental right to data protection, which is something fairly recent in Brazil, but already very consolidated in Europe. The idea of an independent data protection authority, again, this is something recent in Brazil, but a key part of the European framework for data protection. Also, the idea that data processing, personal data processing, requires finding certain legal bases that legitimize and enable this processing to be made in a lawful manner. And finally, the idea that data subjects are entitled to certain rights with regard to their personal data, which is true in Europe as well as in Brazil. And as you were mentioning at your opening statement, Luca, there is a clear connection between AI and personal data protection in view of the fact that AI is a technology that feeds on personal data and non-personal data. It's based essentially on the processing of large amounts of data. And in this sense, perhaps one of the important challenges we have ahead of us, both in Europe and in Brazil, is in fact how to harmonize existing legislation on personal data protection and future legislation on AI, and how to make sure also that the technological development of AI takes into account the importance of protecting not only personal data, but also other fundamental human rights associated to individuals and their relationship with technology, both in the public and in the private sector. So I think these are some of the concerns that have been on the table for some time now in Brazil and in Europe as well. And I'd like to just briefly touch upon some of the points of intersection that I see between AI and personal data protection. Points of intersection and perhaps also challenges for our policies and for our academic debates. So the first one refers to the several principles that guide personal data protection, both in Brazil and in Europe. And here I could mention a handful of principles, for instance, the idea of data minimization, which means that you should not collect or process more data than is necessary to reach certain ends. The idea of transparency as to the data processing activities, the idea of non-discrimination. These principles are fairly common in many of these countries who have personal data protection legislation, but also in OECD documents, in many international statements. And perhaps one of the most challenging principles when we discuss AI and personal data protection is the idea of purpose limitation, purpose specification. So this is common in many jurisdictions. And the idea is that you should not use personal data protection for other purposes that are not compatible with the original purposes that justified collecting data. So you have to specify what that data is going to be used for. And of course, when we discuss AI, we are discussing the possibility of combining data sets that come from different origins and creating novel insights, new information, producing more data about individuals, making inferences about their personality traits, about their preferences. So this, I think, is a huge challenge. And I think perhaps one of the important issues to be taken into account is what are the expectations of data subjects, right? And then a second point that connects to this one is also the idea of data subject rights. This is also common in the GDPR, in the Brazilian legislation, in OECD documents. There are a number of data subject rights that are recognized, I'd say, internationally in different countries, such as the idea of the right to access to personal data, the right to correction of personal data, cancellation, the right to oppose personal data protection when it violates legislation, and also more complex rights that have become, more evident and come under more scrutiny recently, such as the right to explanation, the right to review automated decisions. And these are rights that exist in our legislation here in Brazil, although they have not yet been regulated, but certainly bring a strong impact and have a strong intersection with discussion on AI regulation. Not only because these rights are complex and we are not yet sure what they mean in practice, but also because the technology has certain characteristics, as Maria was saying, such as opacity, such as the risk of bias, for instance, which make it also technologically very challenging to exercise these rights in certain circumstances. And the last point I'd like to mention very briefly before closing these opening remarks is a discussion on, in fact, institutional and administrative arrangements with regard to AI regulation. So I think a question that is in everyone's mind right now is, who is going to be the AI regulator? Will we have a single regulator? Will we have several regulators? Who will be responsible for enforcing the new legislation once it is approved in Brazil, but also in Europe? And in fact, what does this regulation consist of? What is the scope of the regulation we are discussing? And here I'd like to highlight the challenges of having multiple perspectives of AI regulation, because on one hand, we have, of course, a strong concern with human rights, with fundamental rights, with the idea of trustworthy, human-centric AI, as Maria was mentioning. But then we also have issues related to industry and safety standards, for instance. We have issues related to incentives to innovation. We have discussions on innovative regulatory approaches, such as responsive regulation, regulatory sandboxes, and so on. So I think this brings a very complex discussion. where we may perhaps not find the same solution as Europe, because our own institutional framework in Brazil is, of course, different. We have our specificities, but I think in this huge discussion, an important question is what will be the role of data protection authorities? Because of course, the commonalities are very intense. And in fact, we are discussing a technology that is based on processing large amounts of personal and non-personal data. So I don't have answers to all these questions, but I think setting the stage and posing these questions is perhaps the most important step for us to move forward. So I'd like to close these very brief remarks saying that I very much look forward to hearing the other speakers, and thank you once more for your invitation, Luca.
Miriam, thank you very much. Thank you very much for your very interesting what you said, and maybe we can comment later. But now I have to give back the floor to Maria, because meanwhile she was speaking, the connection freezed. I don't know, Maria, if you are there.
Yes, I am. I don't know if you can hear me.
Yes, Maria, sorry, if I may,
Yes.
I would like also to make you a question. Without to enter in political debate, is the last thing I would like to do, is it seems that the new government wants to relaunch, to have a stronger relation with Europe. And regarding Horizon Europe, if I'm not wrong, Brazil is not yet an associate country. So what do you think could be done in order to increase the cooperation between Europe and Brazil also in the field of research?
Yes, no, thank you. And sorry for the connection problem we have here in the delegation today. Yes, indeed, well, Brazil still has the opportunity to participate in calls if it joins a European institution. So that is always a possibility. And another possibility would have to have dedicated calls to Brazil, as we used to have, especially on the digital matters. So that is something that we could consider. Well, if it was on me, I could definitely go ahead with it, but of course the Brussels needs to decide on this.
Sure, sure.
I don't know exactly when I was kicked out. I just wanted to mention very briefly that we have initiated the implementation of a Team Europe initiative. Team Europe is EU plus EU member states plus European Investment Bank. Here in Brazil on digital transformation, and artificial intelligence certainly will be an important topic to find cooperation activities and define some joint activities. And also that we are planning to organize EU-Brazil Digital Days in September 2023, likely complementing the Painel Tele-Brazil event. So please stay tuned, because we hope to continue the dialogue with legislators and also try to showcase some AI use cases from Europe on health, agriculture, and car manufacturing. So those, I think, there are some interesting activities, joint activities that we would like to do here in Brazil. So please stay tuned, and thank you again for inviting me. It's a pleasure to share time with also with Miriam and all the other speakers. Well, I'll continue being in touch with you, Luca, and hopefully we can see each other at future events. For now, thank you so much.
Maria, thank you very much. I think this kind of a conversation are very important. And I hope also, thanks to Luca, that in the future we may have more opportunities. Now, let me start with the second part of our webinar. And the first is called opening segment, and this is a core segment. And now we move to discuss about AI governance and regulation. The first speaker is Juha Heikkilä. He is considered is one of the major European experts in artificial intelligence. He has been head of robotic and artificial intelligence, the European Commission, and today is international advisor for artificial intelligence. I think that he may address us some aspect of the AI Act and its impact on the AI sector, and also its enforcement mechanism. Juha, the word is for you.
Thank you very much indeed. Good morning to Brazil, and I'd like to first thank you very much indeed for this invitation, the kind invitation. I'm very glad to be here and give you a bit of an overview of what the European Commission is doing in terms of regulating artificial intelligence. Now, given the constraints of time, I think I'd better just focus on the overall background, the rationale of the Artificial Intelligence Act and the logic of it. So why we regulate AI, how we go about it, and what are the characteristics of the approach that we have taken. So first of all, artificial intelligence, we concluded long ago that this is a very powerful technology or a set of technologies which can be very powerful and good for our citizens, businesses, and the public interest. So it can help us tackle many societal challenges, and it can improve the quality of our lives. But at the same time, as has already been pointed out by previous speakers, it does come with certain risks. And in particular, it comes with risks to the safety of consumers and users, and it comes with certain risks to fundamental rights. So there is the good side and the less good side of artificial intelligence, as we've already stated. AI systems, why do we regulate? Because they are complex, they can be opaque, unpredictable, they can have a lot of autonomy, they consume large amounts of data, and all these combined have certain consequences, like the risks that I mentioned to safety and fundamental rights, but it also raises questions about enforcement. It can create legal uncertainty, it can create mistrust. And from the perspective of the European Union, of course, since we have a single market, but the European Union is not a country, but a union of member states, there is the risk of fragmentation. The fragmentation aspect, of course, has two sides to it. So there's, on the one hand, the fragmentation of the legal landscape on AI, which would be obviously bad for the single market, but also then the fragmentation resulting from that in terms of the capability to invest and develop artificial intelligence. So for these reasons, we think we have to regulate AI. And trust has been mentioned, trustworthy AI, as the cornerstone of our approach. We all want to have the benefits of AI, but for the benefits to materialize, we need to have the take-up of artificial intelligence systems and technologies. But that take-up presupposes trust. So for the benefits to materialize, we need to enable the take-up to happen, and that requires trust. So therefore, we need to ensure trust, and that's what we do in our approach. That's what we want to achieve in our AI regulation. Now, our approach is a risk-based approach, so it applies to certain uses of AI, and we have set up a pyramid-like hierarchy of risks. So at the top of the pyramid, we have unacceptable risks, so certain rare uses of or few uses of AI which cannot be accepted, which we have prohibited or would like to prohibit because they are in such obvious conflict with the EU values and fundamental rights. So these include, for example, general purpose social scoring and subliminal manipulation resulting in physical and psychological harm. Then, if you like, the core of the proposal is the area, the category of high-risk systems. So these are permitted subject to compliance with the requirements of the AI Act and an ex-ante conformity assessment. So those uses of AI where the risk is considered to be high, these will need to be checked for compliance with the proposed regulation. And the mechanism is conformity assessment. And those high-risk systems are defined in an annex to the regulation, and they come in two types. So there are firstly the safety components of certain regulated products. These could be, for example, medical devices or machinery. which are already subject to third-party assessment under the relevant sectorial legislation. And then there are certain standalone or embedded AI systems in certain uses, certain fields. For example, the biometric identification and categorization of natural persons, the operation of critical infrastructure, law enforcement, and the administration of justice and democratic process. Just to give you a few examples, there are in total 8 categories in this regard. So these so-called high-risk systems will have to comply with the regulation, and the providers of these systems will have to go through the conformity assessment before those kinds of AI systems can be put on the market. Then further down the pyramid, we have certain transparency obligations. So, for example, bots, the user will need to know, will have to be informed of the fact that they are not dealing with a human being, but with a bot. And then at the bottom, at the root of the pyramid, if you like, at the base, we have minimal no risk. So these are uses of artificial intelligence which are permitted without any restrictions. And the requirements that concern then the high-risk use of AI, they concern data, so training, validation, and testing data. They are related to traceability and auditability. Information, provision of information about the use of the system, so a certain degree of transparency and information provision, and human oversight, robustness, accuracy, and cybersecurity. So these are the kinds of areas where then the regulation provides for requirements which need to be fulfilled by those providers who wish to put high-risk systems on the EU market. And there has to be then the associated risk management processes that make sure that the systems are governed by it. And this all in the light of the intended purpose. So the use of the system and the intended purpose, they are the key concepts here in this AI Act. Now, some characteristics of this, what it means, what I just briefly explained to you as the core approach and the characteristics, the approach, how we go about regulating AI in addition to why we do it. So first of all, as I already said, it's the risk-based approach. So it does not address AI across the board. It addresses certain uses of AI, those uses where we think it's necessary for us as regulators to intervene. It is meant to be proportionate and innovation friendly. So we are seeking the right balance between innovation and protection. So the proportionality comes already from the fact that it intervenes only where necessary. And that enables then innovation to thrive because it leaves scope for innovation in cases which are fully legitimate, and ensures that those cases where there is risk, they are taken care of by means of the mechanism of requirements and conformity assessment. It is also a flexible approach because the high-risk systems as defined in the proposal can be then modified. The list of high-risk systems can be adjusted as appropriate. Obviously, this is a technology which develops very quickly, so we need to be able to deal with that and the changes and respond to the changes to take into account other high-risk systems which may emerge or high-risk uses of AI systems. And finally, I would like to add that this is not targeted against any particular set of providers, of course, but it creates a level playing field, so it applies to all providers equally, providers which want to put AI systems on the EU market, regardless of where they are based, whether they are based inside the Union or outside. So this is in a nutshell why we regulate AI, how we go about it, and what are the key characteristics of our proposal. Thank you very much indeed.
May I, before to pass the floor to Luca, just to make a short question to you, but what do you think will be the impact of ChatGPT? What has changed for you? Yes, please.
So this is actually so the current state of the process is such that the proposal that the European Commission made in 2021 is currently being discussed by the co-legislators. And they are certainly discussing this. At the moment, I cannot predict what is exactly going to be the solution that is going to be adopted. Initially, of course, given that we have a system where we would certainly need to have transparency requirements applying based on the original proposal. That's one thing. But then this is a broader question related to general purpose AI systems, not just this particular one system, of course. And there currently the discussions are going on how to go about dealing with it, whether and how it should be taken into account. The Council of the Member States, basically they published their general approach, so-called general approach, which is their position on the AI Act. This was published in early December last year. And there they have put requirements for general purpose AI systems. So they, in that proposal, they consider them to be high risk AI systems. However, this, as I said, already the possibility that they could be used for high risk systems in the past, that was in a way in the original proposal already covered to the extent that they would be used in high risk systems. But now the discussions are open, and it would not be appropriate on me to try to second guess where the discussions between the co-legislators are going to go then, because this will now be discussed between the Parliament, the Council, and the Commission in the coming months, and the outcome at this point cannot be seen yet.
Thank you very much, Jukka, for these precisions. And actually, let me also remind to all people that are following us that we are using the application Slido to collect questions for the panelists that we will have during the question and answer segment at the end of this webinar. So if anyone is interested in asking questions to the panelists, please use the Slido application. You will find it in the chat of the YouTube video that you are watching, right? In the first description of the webinar, you will find it. So please use it if you want to share questions. Now, without further ado, I would like to introduce our good friends, Laura Schertel Mendes, who is professor at IDP at the Brazilian Institute of Public Law. She directs CEDIS there, and she had the honor of being appointed the rapporteur of the Senate Commission of Jurists that helped the Senate create let's say, an expanded and further structured version of what could be a proposal for an AI regulatory framework. Brazil had a couple of bills that were introduced in the Congress over the past couple of years, but they were all very concise, let's say, to use an euphemism, so between 6 and 10 articles, criticized to be a little bit vague. And so the tremendous work that has been done by this commission of jurists, that was of which Laura was the rapporteur, and also Miriam was one of the members, has advanced a lot in the national thinking and the national debate also, because we have had a very long period of public consultations, multi-stakeholder consultation, where our center was able to participate, and a lot of stakeholders around Brazil were able to provide feedback and inputs on how to shape this new proposal. So please, Laura, the floor is yours. We look forward to hearing.
Thank you so much, Luca and Luigi, for the invitation to participate in such an important and high-level debate. Can you hear me well? Yes, okay, thank you. So I'm a professor at IDP and UNB, as Luca already said, and I'm currently in Frankfurt as a senior researcher at Goethe University. And I worked with Miriam, with Ricardo Cueva, the president of this legal experts committee at the Senate, and alongside with more 15 colleagues on a proposal of a draft bill for AI in Brazil. So I would like to give a brief overview of this process of regulating AI. And I'll start at the beginning of this process. In Brazil, the intent to regulate, as Luca has already told us, started in the year 2019. 2 bills have been proposed by the Senate and 1 bill was proposed by the House of Representatives. And on September 2021, the House of Representatives has approved Bill 21 from 2020, in a very expeditiously way. And this triggered a lot of, I think that was very interesting because this approval, the approval of the bill has accelerated this debates and the discussions of AI regulation in Brazil. And this process triggered a lot of criticism, both for the extremely accelerated process with little debate and for the content of the bill itself. It had many shortcomings, such as the fact that it doesn't address the negative impacts of AI. It revokes existing norms and doesn't provide any governance structure, just to mention some of the problems. For that reason, when the approved bill came to the Senate, in order to be voted, the president of the Senate has decided to install an expert committee to discuss the issue and propose a new bill. The aim was to deepen the debates and allow a more comprehensive analysis, as well as enabling more stakeholders to join a public debate. After 9 months of work, during which more than 60 experts were heard in multi-sectoral public hearings and 1 international seminar, the committee presented a report with the draft bill on AI regulation. This was December from the last year. The hearings brought many important inputs, and I would like to highlight some of them. One of them, I think the first one, is the idea that principles or ethical principles alone were not sufficient to guide AI providers and operators anymore. It has been said very strongly that there is a need of more concrete norms. So there were we have heard that this idea that we need more concrete norms, more binding rules. I think this was very mentioned in these hearings, and I would like to highlight this point. The other aspect is that the concept of AI should cover not only machine learning, but also approaches using logic and knowledge representations, since one has to look at the impact of these systems. Another interesting point of the hearings is that a centralized governance structure is necessary to guarantee the rights of those affected in a harmonized manner and to provide legal certainty. And the last one, the idea that a society as structurally unequal as the Brazilian one needs to pay special attention to the discriminatory potential of AI systems derived from technical and social biases. So after analyzing all the inputs that we received, as well as examining in depth different topics, the committee decided to adopt a comprehensive approach of the law. This is due to several reasons. For instance, consistency and continuity in the Brazilian tradition on regulating technology. We are used with comprehensive laws such as the Brazilian Civil Rights Framework for the Internet, the Consumer Protection Code, and the Data Protection Act. The idea and that there are some limitations of the Data Protection Act when we are dealing with AI. One of the issues that we're discussing here, and it was all already mentioned by Miriam Wimmer as well. So on the one hand, training data isn't always personal data, and data protection law wouldn't apply always in this context. And on the other hand, applying data protection rules to inferences is also challenging, as the studies by Sandra Varta, Brent Mittelstadt, and others shows, just to mention some of the challenges regarding data protection and AI. The whole life cycle of AI must be covered, not only the decision-making process, such as we see regulated in data protection laws, but also the creation of models and data training. So we understood that a comprehensive regulation with a central coordination seems the best way to achieve the goal of harmonized standards and enforcing rights regarding the impact of AI, also in specific sectors. So the bill has 5 main axes: principles, a list of rights to affect people affected by AI systems, the categorization of the level of risks of AI systems, and governance measures and requirements, and the last one, an enforcement structure. I will try to be brief. I would say that we established some principles, and regarding in this sense I would say that that many documents were important to these principles, like the UNESCO recommendations, OECD recommendations as well, and the AI Act too. So I will mention some of them: self-determination and freedom of choice and decision, human participation in the artificial intelligence cycle and effective human supervision, non-discrimination, fairness, transparency, explainability, intelligibility, truthworthiness and robustness, due process of law, traceability of decisions, and non-maleficence, just to mention some of them. The draft foresees rights as well for people affected by AI systems, which must be observed by providers and operators of the systems, and which are also enforceable by administrative and judicial authorities. This I would like to highlight. I think that's quite a different approach from the AI Act. And we thought we have reflected a lot on this issue, but I would say that we couldn't, for us, it would be difficult to understand that a great enforcement or a strong enforcement could we could have a strong enforcement just with this administrative approach. So we think a judicial approach, a judicial enforcement would be necessary as well. That's why we think this rights it's important, and that is why the draft foresees some rights, but just when there are really people that are affected by AI systems. So just to mention some of the rights to receive prior information regarding interactions with AI systems, the right to explanation, the right to challenge decisions that produce legal effects or significantly impact the interests of affected party, the right to human determination and participation in AI decisions, taking into account the context and the state of art of technological development, the right to non-discrimination, and the right to privacy and personal data protection. All of these basic rights aim to increase citizens' trust in AI systems, in addition to implementing at the legal level the constitutional principles of transparency, due legal process, self-determination, and equity. The risk categorization, which makes up the second axe of the proposal, operates with 2 main categories that receive differentiated treatment throughout the text: the AI systems classified as excessive risk and those classified as high risk. It is up to the system provider, prior to placing it on the market, to perform a preliminary assessment to classify the degree of the risk. High risk systems, for instance, are described here in the draft, or includes systems applied in areas such as the operation of critical infrastructure, education and vocational training, recruiting, private and public services that are considered essential, credit assessment, administration of justice, health, and criminal investigation, among others. The third axe of the bill is composed of governance measures, which constitute a set of due diligence and internal processes to be adopted by the agents that provide or operate AI systems, such as the adoption of transparency and data management measures. High-risk systems require for their implementation the observation of specific governance measures in addition to those that already apply to all systems. Among these measures, I highlight the algorithmic impact assessment, documentation, the use of tools to automatically record systems operation, the performance of tests to assess appropriate levels of reliability, and the adoption of technical measures to enable the explainability of the results of AI systems. Considering the contributions received by the committee, as I have already mentioned, it has become clear that centralized governance structure is necessary in Brazil to guarantee the rights of those affected in a harmonized manner and to provide the legal certainty for law enforcement. The proposal calls, therefore, for the government to entitle a competent body to enforce the act and to coordinate and cooperate with sectorial agencies. As can be seen, the proposal presented to the Federal Senate by the Juris Committee assumes that safe and trustworthy artificial intelligence systems can be implemented by guaranteeing rights and structuring a system of governance and forecasting obligations according to the respective risks generated. As AI applications are continuously being introduced in diverse areas and with varying degrees of implications, it is necessary to consolidate a human rights-oriented regulation and develop a regulatory framework which should combine hard law and soft law instruments, concrete rules and general principles, ex ante and ex post instruments, as well as regulatory approaches capable of ensuring and promoting innovation while respecting the diversity of AI applications and risks. We expect that the draft bill will be soon submitted to the formal legislative process and improved in an open and democratic procedure. I think I could give this overview, and if we have then some questions, I am here. Thank you very much.
Thank you very much, Laura. Now let me give the floor to Andrea Renda. Andrea is professor at European University Institute and is also researcher at SAPS. Andrea is one of the main experts in this matter, and I think he has been since the very beginning in the group of experts of the European Commission. And I think he should address the issue how to reconcile the artificial intelligence value chain with the EU Artificial Intelligence Act. Andrea, the floor is for you.
Thank you very much, Luigi. Thanks, Luca, also for the invitation, and thanks to all the other speakers that preceded me that have said almost everything that needed to be said. So I can concentrate on the on giving some additional thoughts and perhaps some opinions on how this process has unfolded, in particular in Europe, and what are the potential lessons learned in the mutual understanding and mutual learning, as Luigi was saying, with Brazil. And also thanks to Laura for giving the explanation about the current state of the proposal and the structure. And I think this is great work. And it's very, very encouraging to see a legal system such as Brazil going this far into what I will define in a few seconds as one of the most difficult endeavors on earth. So, trying to regulate artificial intelligence, where the EU and UHA, representing the Commission here, has been brave enough to be a trailblazer, right? So first of all, looking at Miriam, and the question that Luca was asking Miriam, I think we are starting to see in Europe some first decisions by data protection authorities that look at chatbots and their potential use of personal data. I think a few days ago, the Italian Data Protection Authority released a decision on a chatbot called Replica, which interacts with end users in English language, a bit in a sort of a more sketchy way, if you wish, compared to what ChatGPT will be able to do also orally going forward in terms of a conversational bot, prohibiting this chatbot from using personal data because it was found that it was giving, in particular to minors of age, particularly inappropriate information. Now, that said, who wants to regulate AI? I mean, Brazil and EU apparently want to regulate AI, and many other countries have potentially made one step forward in this direction, but also a couple of steps back, if you wish. So I think we are talking here about experts from two legal systems that are trying to model the regulatory framework for AI in a comprehensive way. So I'll give you a couple of examples, because obviously the two legal systems that they are shaping up, they have been described. Yuka, Laura have described them. If you look elsewhere, you see, for example, that there's a number of countries who've opted for almost purely self-regulatory framework, and starting with Singapore, but I would say also the UK today, with some specific cases in which there is more, let's say, co-regulatory approach, but in most cases have remained on a very principles-based stance. And there's another group of countries that have officially or are officially about to regulate, but then the regulation remains very vague, perhaps like the first attempts in Brazil, as Luca was mentioning before. So there is a communication or a resolution or a piece of legislation being issued by a government. I would say, for example, that's the case of Canada, but it's potentially also the case of the blueprint for an AI Bill of Rights in the United States. But then this remains at the level of principles, and it then demands to further future attempts, perhaps more in a sector-specific way, really the shaping of rules, the shaping of obligations, and the governance that comes with it. And that's quite important, because many countries have found it to be extremely difficult to find a one-size-fits-all recipe for AI. Why that? Because it's a general-purpose technology. It's a pervasive technology that lends itself to a variety of different use cases, different tiers of risk. It's very complicated. So why do you want to go about that? And then I'll try to defend the case for regulating AI anyway, but it's difficult. Once you start to dig deeper, we've seen that in the EU. So perhaps go through the value chain issue as well. Some of the key problems that we are still struggling with. The first one is, and Laura made a reference to what is happening in Brazil, is the definition of AI itself. You want to define AI in a very broad, technology-neutral way, and then encompass specific AI techniques that might be more, say, rule-based, other ones that are more learning-based, and give the possibility to regulatory authorities to look into all of them, and so trigger regulatory compliance, but by those that provide all these types of AI applications. Or you want to concentrate on applications, for example, that use machine learning techniques, because you think that the problem is going to be there because they're more data intensive, they are learning based, and so on and so forth. Well, the issue is still open at the EU level. The original definition by the European Commission is broad and technology neutral, but the Council of the EU has offered a definition that speaks of systems that infer how to optimize specific tasks or functions, and thereby and with a degree of autonomy. It's also to be discussed, and those systems end up coinciding much more with the machine learning ones than the expert systems, for example, or rule-based systems. Again, the issue is still open, but sometimes the issue is also mystified in the public debate, because there's a lot of people that say it shouldn't be this broad, because if you adopt a very broad definition, you're over-regulating. And here's a little bit of a problem in sometimes having a too rushed debate, because obviously the original proposal of the EU AI Act, the fact that you define AI broadly doesn't mean that you regulate everything, as Yuha was explaining. Then within this bigger perimeter, you actually have to locate the high-risk applications, and those high-risk applications, depending on where they are and how they manifest themselves, will have to comply with specific regulatory requirements. The original proposal of the EU was rather minimalistic in its approach to high-risk applications, identifying a few applications of AI. The discussion among co-legislators has so far a bit expanded this list of high risk, also a little bit the risk of unacceptably risky applications, if you wish. So I would say, in general, in terms of lessons learned, what we start to see now, but here's my personal opinion, it is much better to adopt a very broad and technology neutral definition of AI. The additional reason for this is not just that the also international debate is going in that direction. See that Brazil, for example, is a member of the GPI, the Global Partnership on Artificial Intelligence, and also at the OECD level, the definition tends to be technology neutral, let's say. But the other very important set of explanations for this is the fact that you don't want to give perverse incentives to the people that develop AI to perhaps choose a suboptimal technique just because they don't want to fall under the AI Act, for example, so they will not be subject to regulatory requirements. And at the same time, since in observing the way in which AI reaches the market, we see that many techniques actually are blended into the same AI model. So they could have some elements of rule-based and other elements are learning-based. It will be even more difficult. I already defined it as a very difficult endeavor. It will become really impossible to actually enforce regulation by distinguishing which parts actually should be subject to the regulation, which other parts of a single AI model should be subject to regulation. And that's one example of how difficult it gets. I'm pretty sure that eventually the broad technology neutral definition will prevail. But then obviously you might want to define a little bit better, depending on the sector, depending on the use case, what are the techniques that create more concern, and what are the techniques and what are the regulatory remedies that are most appropriate for that specific use case and application. So again, what I anticipate as a possible outcome of the negotiation among co-legislators, especially for our Brazilian colleagues that are still looking into potential solutions, and also looking at Laura that said, we want to have a broad application and enforcement, and also the judicial part. Two things. One is what I would expect is a general technology neutral definition of AI, but then the possibility for the future entity, authority, board, office that will coordinate and oversee the overall implementation of the legislation to be working with sectoral regulators to further fine-tune and specify, and so spread regulatory certainty for the market players in explaining how this general framework then can be tailored and fine-tuned to the specific sectors and use cases. So explaining a little bit more what are regulatory for example, risk mitigation measures that make sense for that specific applications, rather than always applying the full menu of regulatory remedies to each and every high-risk application, because this otherwise might create a lack of clarity and perhaps a lack of precision in the AI Act. So broad, technology neutral, general, but at the same time, tailored through soft law and interpretive guidance, which I think is perhaps the right combination of what Laura was mentioning before, hard and soft law together to really ensure that the legislation is adaptive enough and adjusted also for the specifics of individual use cases. Now, that said, the second thing I wanted to say about this is that the EU in September last year also presented a proposal on adapting tort law, let's say, liability rules for the case of AI systems. And there is where you might see a little bit more the judicial aspects that also Brazil has decided to introduce. And there is a matter that will need to be discussed also between co-legislators, but adds an important element to what is the original architecture of the AI Act by complementing that with tort law, basically. So rules on liability, and in particular, the reversal of the burden of proof in what otherwise would be normally a fault-based liability system. And for the lawyers in the room, a Lex Aquilia type system in non-contractual liability. Now, that said, going a little bit faster because I don't want to take too much time, once the definition problem is addressed, you have a number of problems on who complies, who should be subject to this regulation. And this is where the value chain issue comes into place. The original text focuses on the provider of AI systems, right? And so the ones that put it into service or place it on the market. And but in practice, if you see the value chain of AI, you see that typically there's a design phase, a development phase, there is a deployment phase in AI, there's a usage phase of AI, right? And so the real question from a legal and economic perspective, if you want, from a law and economics perspective, would be, who is along this value chain best positioned to identify the risks that that model might generate and take corresponding mitigating measures, right? So in some cases, there are some risks for safety or fundamental rights that could be spotted already at the design phase or at the development phase. But the idea is that in most cases, not only the risks are more easily identified once the actual application and the context of the implementation, the deployment of that system is decided upon, but also the potential mitigating measures. What do you do with the data? What do you do in terms of human oversight? What kind of transparency you give to the end user, and so on and so forth. These are things that are normally best handled at the end of the value chain, right? While we were discussing these things and originally imagining, and the Commission imagined, we put a focus on the provider of AI systems. An issue has emerged in the discussion on the AI Act as to whether this would not put too much burden, for example, on the small and medium-sized enterprises that purchase AI models from larger developers, for example, tech giants, and then put them into service or place them on the market by having to undergo conformity assessment. And so a number of provisions have been introduced in the AI Act gradually to try and strengthen a sort of a solidarity and cooperation between those that develop and those that deploy. And this is something that ended up also affecting general purpose AI systems, or what we will call today large language models, right? In this case, the issue becomes a little bit more complicated because many of these big models that are being deployed are offered on the market either as open source. And so it really remains to be decided whether you want to put some liability and some responsibility on top of these companies, at least to give more documentation or to monitor use of these AI systems on the market, or when they are offered through an API that doesn't really give any possibility to change the model once you have accessed it and deployed on the market, whether there is anything that could be done to ensure that those that put into service or that place on the market through an API this very, very powerful system, that they do whatever they can to, one, give more guidance as to how these systems are being used, and two, if possible, track and monitor how these systems are being used and take action if the systems are being used for whatever use that appears to be too risky or causing unjust harm to end users or a group of end users. So these are just some of the problems that we've seen. Now, of course, I could go on. I will not, because I don't want to take too much time. But some of these decisions, and the more we look into the AI Act, the more we discover how complex is the subject matter. And there's a trade-off to be struck between getting it right and getting it fast, because, for example, the issue of ChatGPT or even large language models was not in the head of the Commission when the Commission placed the AI Act or proposed the AI Act in the first place in April 2021. If we wait for another 6 months, GPT-4, Gato, Lambda, many others will come out, and it will be a nightmare to try and really keep the pace of innovation. Which means the AI Act has to be good enough and also has to be flexible and adaptive enough to stand the test of time, and so to be adjustable and adaptable by the European Commission and other relevant institutions as the subject matter evolves. So hope that was useful. Happy to continue the exchange. Give back the floor to either Luigi or Luca, and thank everybody for the invitation.
Thank you very much, Andrea. This was really enlightening as usual, and I really liked very much actually 2 points that you raised that I think are really key for this conversation. First, the fact that it is a highly complex set of intertwined topics, and therefore we really have to design future-proof laws and take into account the complexity of this item from the very design of the law. But then the second point that is actually what I was also stressing at the very beginning is that even if we have a wonderful law, then that is only the start, because then we have to implement this wonderful law. And so far we don't have AI agencies. They don't exist. Maybe in China, with the Cyberspace Administration of China, there is something that is close to an AI agency, but neither in Europe nor in Brazil, nor in most of other countries, there is an agency with this very rare and difficult set of skills to implement well enough this kind of law, and with this kind of budget. It's really very much a question of human and financial resources to understand how all this complexity plays off and to give the right guidelines. I mean, you very well stress the complexity of the value chains. I mean, to take the example of how I was playing with ChatGPT during the weekend, as soon as Microsoft will integrate it into Bing, as they announced recently, they will need to comply with the right to be forgotten because they are search engine. But it is ridiculous, as ChatGPT replied me, to think that OpenAI that develops it does not have any responsibility, as they are collecting, hoovering the personal data of virtually anyone and reprocessing them to provide an output when they receive a query. So there are very complex questions. Who is responsible and who is the watchdog that will have to implement this? Also, this is complex. I mean, we have seen only last week that the French and Dutch Data Protection Authority announced new units to deal with AI oversight. Wonderful, but as we were stressing since the very beginning, AI is not only data protection. We need not only a dedicated agency able to understand this, but also a system able to put in contact the existing agencies that have remit on this. And this is extraordinarily complicated. Now, probably we will hear a reply, to all these very complicated questions with our friend Eduardo Magani, who is a professor at Católica Law School. He is associate at Harvard and also a visiting researcher here at CTS FGV. And he has been working a lot also with some recent project with the Brazilian Ministry of Economy regarding AI ethics. So please, Eduardo, the floor is yours. We look forward to understand also how AI ethics still play out in this very complicated context.
Thank you so much, Luca. It's a great pleasure to be here with you all, alongside so many friends. So congratulations. Thank you so much for organizing this very, very nice event. So indeed, I've been working a lot in the last years with companies and governments in Europe and Latin America. I don't want to take too much time, but I want to add some points to this already excellent discussion here. I really like this idea of Brazil and Europe cooperation because I think it's been really, really fruitful. And we can think about what is going on in the field of data protection and how much Brazil is really catching up in this discussion and learning so much from the European context. In countries such as Germany, they have a national data protection regulation since the 70s. And this is a sort of a new topic in Brazil, but I would say that I'm really, really happy with the evolution of topics such as privacy and data protection, because I think Brazil is really catching up. The same way that Brazil is catching up in the topic of privacy with all the help from the new Data Protection Authority, all the help with Miriam Wimmer that is here with us in this event, I would say that we are evolving in the same way with the topic of artificial intelligence as well. So I think those lessons learned are really, really important to be taken into consideration. And Europe is doing a great job in producing more and more robust opinions around this. Europe is also learning with the topic of artificial intelligence, but we have seen many frameworks in the topic of ethics that Luca was mentioning before. We have really robust opinions going on that should be taken into consideration by Brazilian legislators and scholars as well. The maturity of this debate is shifting a little bit. I remember 10 years ago when we were discussing around the topic of AI, the importance of opening up black boxes. And at the same point that I recognize the importance of this expression by opening up black boxes, I wouldn't say it serves us very much nowadays, because I think it really simplifies algorithms and the impacts that algorithms have in society. to open up an algorithm shouldn't be that fruitful for the impacts that we want to envision and the rights that we want to protect. What we really need to understand right now is how the automated decisions are impacting society and how are they taking place specifically. So some complex algorithms, such as neural networks and deep learning algorithms, simply cannot be understood the way we wanted many times. They cannot be completely explained by technicians or programmers. So we really want to think about what is the minimum information and explainability that we should expect from those complex algorithms. And I think this adds a complexity in this discussion that we didn't have 10 years ago. So we need to really understand the differences between different algorithms and what exactly do we expect to be explained in these decision-making processes coming from algorithms. So we have a more mature debate right now. And the same thing happened with data protection that is becoming more and more complex, not only touched by topics such as AI, but for other discussions such as reasonable inferences that were considered as like gaps in robust regulations such as the GDPR. So we have something similar with AI right now. So I really like to compare the discussions around data protection and the cooperation that we have between Brazil and Europe and the ones that we are about to have from now on in those two contexts. Trying to interact with previous inputs that we received here in this event, taking the experience that we had from Marco Civil da Internet, from the Brazilian Internet Bill of Rights, I do think that regulation is necessary. The thing is, how exactly should we regulate AI? And agreeing with Andrea, this is one of the most difficult endeavors that humanity has from now on. But it's very, very important to regulate. And I remember 15 years ago, this discussion of having a non-regulated internet or digital sphere. So I think we should keep this aside, understand that some regulation is very, very important to guarantee rights. And I'm very happy with the evolution that this is taking in Brazil, with all the effort from Laura and many other colleagues of mine in the Senate, with the expert commission that we have in this new draft that really addressed very well some gaps that we have even in the AI Act in Europe. In this new draft, we have a very clever approach, not only a risk-based approach, but also including very important rights. So I think regulation is important, and the perspective that we are going with in the Brazilian context by combining risks and rights is a very, very clever one. So this is just to start. And Andrea mentioned the complexity of the concept, and I totally agree. We have to think about a future-proof concept to including those regulations. And I think, again, the draft was very clever to make it broaden enough to permit the legislation to evolve, following the pace of technological development. So I totally agree with Laura and Andrea in that sense to keep the concept broad enough. So this is just for starters, because the AI Act really struggled in the topic of the complexity of the concept. But now, after receiving many, many inputs, on that side, I think Europe is understanding this importance, and Brazil is doing a very good job with these lessons learned from the inputs that we received in the European context. Besides scoring pretty much well with the concept of AI in the new draft, I think our new project bill addresses very good points. I mentioned the mixed approach between rights and risks, but I wanted to pinpoint some other things that are included in the draft, which are algorithmic impact assessments, besides privacy impact assessments. They're pretty well known in the privacy field, but AIA, algorithm impact assessments, is something sort of new, but it's hugely important in this debate. And both companies and public entities should be aware of these new assessments. An ex-ante and ex-post approach as well, understanding the importance of not only privacy by design, but also security by design, and I would add ethics by design as well. So both approaches are very important. By design ex-ante, but also an ex-post approach, which is in the draft as well. Stating prohibitions, which is a sort of a sensitive topic because it can really hinder innovation sometimes. But I think we have some brave inputs from the expert commission trying to prohibit some very impactful AI technologies. Dealing with liability and responsibility, again, here, our expert commission was very courageous, very brave by really digging more into the liability stuff, which can be very impactful for companies, most of all. And understanding that this shouldn't be kept only with a competent authority. And I think it was very clever as well to permit the authorities to be oxygenated by sectorial authorities. That is very, very important because sectorial authorities can bring specificities from different sectors that should be included in specific regulations as well. So I think it was very gentle to include in this draft this combination between the administrative national competent authority and sectorial authorities as well. But besides all this, the great adds that we had in this new draft, I would say that we are going towards a very interesting direction in Brazil. But this direction shouldn't be limited to the legislative initiative. Even though we have a good draft right now, I would like to make an invitation for all of us to think about next steps. And the next steps is to think about the implementation plan of all this, considering the differences between the private sector and the public sector, because we have huge idiosyncrasies between those two very different sectors. This is in one hand. And beside this, how to combine the legislative initiatives with what we already have in terms of strategy. Brazil already have a national strategy for AI, which is a very weak one. Now we have a strong legislative draft, but a weak national strategy from the government. How to combine both initiatives, trying to take into consideration that Brazil was a pioneer in different regulations, such as the Marco Civil, the Internet Bill of Rights that I just mentioned, but now not only, Brazil did a great job with the Internet of Things National Plan. So how can we strengthen our national strategies, thinking not only in the legislative sphere, but also combining this with different spheres and trying to include specific ministries. How can we include the economy ministry working with the science and technology ministry in Brazil, and how we can permit to oxygenate itself as public entities with the help of companies in a multi-stakeholder and interdisciplinary approach. Again, to regulate AI is not something easy to do. We're trying to give our best here, but I wouldn't stick to the legislation. I think strategy is very, very important. Look what is happening in Europe right now with the GDPR. We have GDPR into force by some years, we could say right now, but some national authorities are not doing a great job, even inside Europe, in certain countries. Why? Because it lacks budget, it lacks enforcement from those authorities, and it has to do with national culture. So how can Brazil learn from what is going on in Europe, also in terms of strategies and enforcement? And how can we take into consideration the specificities and idiosyncrasies that we have in the Brazilian culture, including Brazilian public entities, as I just mentioned. In the data protection, in the privacy field, we're doing a great job since our national authority is really educating different sectors. It is really producing many robust opinions in many fields. So how can we, in the AI sphere, do something similar to what we're doing already in the privacy field, really trying to make Brazil more protagonist in the AI sector and catching up as good as we are doing in the privacy sphere as well. So this is what I hope and what I try to do with my efforts as well, alongside those great friends that I have here in the panel. So thank you so much. Don't want to take too much to save some time for the Q&A. Thanks again.
May I make just one short comment, Luca, if it's possible, because I think you raised very interesting points, but I think there is one issue that we should take care, the implementation. Because, for example, let's look at what has happened with privacy data protection. If I have to sign, if I say, I agree, otherwise I cannot have access to the service. So I have to read the 40 pages, I don't care, I click on the bottom, otherwise they don't give me access to the service. So what happened in reality, nobody read anything. They click because they want to have access to the service, and therefore once you click, you gave them the permission to do everything. So this we should look also at if this avoid that would happen also with AI, because it will be very, very dangerous. And what the last comment, very short, and I pass the word to you again. At the same time, we are speaking about ChatGPT, but the main AI platform in the world is TikTok. Only experts they know is the main, and nobody knows that they are using artificial intelligence. It's only based on artificial. What are the rules they're using? So this is something that I don't want to open a very big discussion, but Luca, the floor is for you, or again.
Thank you very much. Thank you very much, Luigi. And indeed, I think that is raising another very important question that we are going to, I think, tackle with Nina, which is the fact that we are already adopting AI on a large scale. We might not understand it, but it is already intertwined in many of the products and services we use on a daily basis. And that makes it even more complex on one hand, because again, if we are we have to craft rules that, of course, take into account the future and are future-proof, but also take into account the enormous complexity that already exists, and how difficult, again, it is to understand who is responsible to implement any kind of regulation and how to do it. That is, again, building the bridge between the legislator or regulator and the developer or the user. I see this as the greatest challenge, not really designing the law or creating the authority, which is already in itself something extraordinarily difficult, but having the system, the governance and regulation system that we may want to create, and then absorbed by society, by the economy, and even by democracy, right? So to speak about how this plays out in practice, I would like to give the floor to Nina, who is a researcher here at CTS FGP, amongst many other things. And she really works on this, on how she's a data scientist. She works on how tools are developed and the impact they have on society. So please, Nina, the floor is yours.
Thanks, Luca. Afternoon, everyone. Thank you for inviting me to collaborate on this webinar. That Luca said, I'm a researcher at the CTS, and I have the opportunity to work in the TikTok, with cybersecurity council, and I had the opportunity to collaborate to the government here in Brazil, in the elections, in the other complex situation about AI regulation and algorithms regulation too. So I want to share some perspective that how public opinion influence this debate between AI experts and democracy. First, as a computer scientist, I would like to point out about the hype tech or tech hype that we have the influences in the public opinion. And recently, Trinity Gebru shared about this AI hype, like ChatGPT, facial recognition, and voice biometrics. The first thing in Brazil, currently in Brazil, is one of the countries in Latin America that uses a lot AI social platform and AI service. But in the same time, it's not easy to democratize the information about how these technologies is developed. And AI, specifically AI, have a problem with your literacy because we need to deconstruct the magical about how these technologies is developed. So ChatGPT, for example, is AI technology that use NLP, natural language process. This is a part of the machine learning, but it's not the all AI technologies. So how regulate this part? How think about the regulation specific and natural language process? So in my perspective, we need to break the parts of the AI technologies in voice recognition, facial recognition, algorithms to help algorithms like ChatGPT for education or the other alternatives, because it is really difficult to regulate this AI and look the actual environment to discuss about this. We are talking about GPT with the comments in the other colleagues says some things about this, but this is algorithm is not really a technology, because in 2018, OpenAI, that company that created this model, launched the GPT-3, and the GPT-3 was the first natural language model to create the opportunity that AI algorithms create texts. In 2019, we had big problems with this technology because the OpenAI opened the access to specialists, developers, journalists, but not open the black box on how this model was created, what this model uses to answer our questions. So I needed to do some comments, technical comments, because ChatGPT collect our questions and collect our comments in the chat. So this collected data is used to create new texts and new answers. So we have a little problem to understand this. And in the regulation debate, specifically in Brazil, we have a challenge about difference, ethics in AI, and the responsibility. In Brazil, we We think the ethics and responsibility is the same thing in technology, but it's different. And the companies that uses Brazil like a labor understand this confusion in Brazil and in Latin America. So Brazil, for me, has the opportunity to collaborate with the rest of the world based on its leadership in the civil internet framework and democratic models of internet governance, with possibilities and paths for regulations that center human beings in this debate. So I think it's the time to center human beings in this debate, and not the technology, it's not the big techs, it's not the other companies that uses and create these AI technology. So this is my comments and my shared with you. Thank you.
Thank you very much, Nina. It's been very interesting. And now let's give the floor to the last speaker. At the beginning, we said that the role of industry is very important, the private sector. And now we have Claudio Villar. He's the head of product, data science and supply at Hostel World Group. Hostel World Group is a leader in hostel market online. If understood well, it's a booking of hostel worldwide. And it would be very interesting to understand from him the way they see and the importance of artificial intelligence for their company.
Cool. First of all, good afternoon to all. Thanks, Luca, Riley, for the invitation. It's really a pleasure to be in this round, also with some friends. So it's pretty good for me. Yeah, so I'm going to give like a little bit of context of how I see the bill, like the draft bill that had been proposed in the Brazil court, and trying to bring also like some kind of examples that I had in the industry in the last close to 9 years that I'm here in Europe. I got here in Europe at the time that GDPR was actually being applied in a general term, and working with data science for some companies here. Actually, some of those concerns became really touching our areas of development and engineering. So I think the initial point is that it's extremely important that the draft bill is multisectoral and multidisciplinary. I think AI is making a big favor to us to like involve people from legal aspects, ethical, philosophy, language that we didn't have before, even in computer science as a whole. And AI is actually this bridge of communication towards like a common advance, let's say, for our society. And I think also the draft bill brings us lots of structure to what the public, basically the people acting, people in the countries and the civil rights need to be aware of. So it's also making this effort of bringing the society aware of their rights, what are the risks that they are suffering that sometimes are not perceived by them. The primary examples that we see in this is like the access of information, transparency, right to contest, and human intervention. I think these four pillars of the rights in this draft is actually like convincing, let's say, and it brings us in the engineering side with our foot on the floor. And I also see lots of relationship with what I saw in the GDPR progress of integration in our advance governance on how to deal with users' data. And this is like a super important step. COVID forced companies to be. Sorry, can you hear me? I feel advanced on the governance. I'm sorry, can you still hear me?
We have a little bit of jitter over the past 30 seconds. So if you can, we can now see you because your image was freezing,
I
and
think it's
also
perfect.
now I think it's back.
Yeah.
Sorry, please go ahead.
Perfect. Let me give 2 steps back then. So, like, the impact of GDPR actually helped a lot for the companies to evolve technologically, also for the governance on how we collect the data, how we structure the data, how we storage data, and everything that would make easier for us to be liable to discuss with our users. So I see also some relationship with this new draft view, because it gives us like some kind of framework to think and also to guide our product development. I'm gonna take one example for what happened in one of the companies that I worked. Because of GDPR, we were enforced to not use any kind of personal data or data that would identify a specific user in our recommender systems. So recommender systems, ranking, and so on. We had to avoid using gender, or we're going to be able to see happening on the. I'm thinking. I think I lost again. Yeah, let me try one thing. Sorry.
Now, while Claudio is experimenting with his Wi-Fi connection, I just wanted to invite everyone to include questions on Slido. We already have a lot. I will ask the panelists to kindly stay here 10 minutes, 10 extra minutes, so that we can then reply to some of these questions, but not before Claudio has finished his presentation. Claudio, can you hear us? Are you still here? Claudio, can you hear us? All right, so while we wait for Claudio to reconnect, I think we can start with a couple of questions. We have a lot in the Slido app that have been included by our followers. So first, I would like to start with one from Eugenio Garcia, who is a Brazilian tech diplomat in San Francisco. So he is saying, great discussion. Do we need a national AI authority in Brazil, or are existing structures enough to play this role? Which is also another good one. So this one from Guilherme asking directly to Miriam and Andrea. Well, unfortunately, Miriam has already left because she had a urgent meeting at 2 o'clock Brazilian time, so she already left. So the question is, the ban on replica was grounded on mainly on children and vulnerable people interaction with the bot. Could this precedent be applied to ChatGPT too? Well, that is, I mean, if Andrea wants to reply, but that is also a more ample question. Then we have a lot of other questions, but I see that Claudio now is back. So perhaps while the panelists start to think about their replies to the questions, we can have the last part of Claudio's presentation. Please, Claudio, go ahead.
I'm super sorry about that. I mean, so I'm not sure how far you lost me, and I'm going to try to get back again to the point of GDPR. So the impact of the GDPR in the companies was like fruitful. Because of that, we had to advance also not to use personal data on our products. So I mean, it's like something that would minimize the risks or mitigate the risks that we might have with users. And because of that, one of the use cases that we had was that our recommender systems in one of the companies, we were forbidden to use any kind of personal data, any private data. For example, gender, we had recommender systems that were guiding people to see products related to female, products that were related to male, like, you know, very binarized way. And also due to understanding of ethical concerns on how to aggregate users, we had to remove this information. And we discovered at the very same time that we actually didn't need any kind of private data to achieve the very same return of investment on recommender systems and rankings that we had in our solutions. So we started to use more advanced models and machine learning solutions that were more real time. And because of this real-time behavior and like computing power that now it's available to us, we actually don't need to look for individual users in our systems. So this is like another learning that we had, because by knowing that our business was still stable in terms of recommender systems, by not using personal data, we also found out that those groups that were created internally from the data, just by looking for the behavior of the users, anonymized and so on, we found out that there were some groups that were not covered. So we saw the very same patterns, and we could clearly see who were male, who were female, just by the pure data, without considering the private data of our users. There is a book called Weapons of Mass Destruction from Cathy O'Neill, which is a pretty nice book to discuss the impacts of bias and opacity of the algorithmic decisions. And but there's one thing out of there that sometimes we even don't know where the bias is. We don't know what are issues that we're getting us in, and what are the troubles that we could potentially inflict to our users. So it's extremely important that now we have this kind of guidance, guidelines, tools, regulations, such as it happened for GDPR, to kind of like move and shake companies to follow up like best practices on ethical usage of AI. And this is also important, like following on the Andrea and comments, like where does the accountability reside? I mean, in the process of developing a product, we have one metric to optimize in the company, be it revenue, and that's our main goal. We usually don't care much in super high level terms. We don't care much about the impacts of that. And also some companies and practitioners actually are not even aware of those risks. So governance, guidelines, templates, tooling for impact evaluation are extremely helpful for business to progress. And it's also a way of not breaking or reducing the pacing of innovation. Also, this draft bill talks about transparency, explainability, intelligibility, and auditability. So these are also 3 keywords that I actually got from that. But I want to put like just 2 points on explainability and intelligibility. Explainability is one of the toughest that we have today to give to our users the right to understand. The new advances of neural networks or transformers of the technology behind GPT, ChatGPT, and so on, Lambda from Google. It's just the way that this technology is making decisions is not human readable. And it's extremely hard to make sure that we can trace down or track how the decisions were made when a combination of those models are also part of the process of the development of new products. Again, we heard that we could be using APIs that are external to our usage. Most of the machine learning algorithms today are open source and distributed as open source tools. So the chain of responsibility, it becomes just larger and more complex when we deal with these compounding products that use neural networks. And this turns explainability extremely hard. The intelligibility of those models also is extremely hard to give as a readable output either for law enforcement or our users. And but nevertheless, I think the bill treats really well the boundaries where we can do what we can. You know, like we have governance in place, we do our risk assessments, we know and we track what was the data that had been used to make a specific decision. And ultimately, the openness for human intervention is like extremely important, is a key for the industry to act upon complaints out of the market. One scenario that we had with this also, to put a little bit of the opaque biases that, and also somewhat related to explainability. In one of the companies, we had specific areas of with underwears. And underwears is a bit funny because we built a model to remove all the products or underwears that had nudity on that. So we had like a nudity classifier to filter all the products that were bad for our users. And we had to scale to other countries. So we had this model running for European countries and so on, and we were migrating or opening business in Asia. And some of those underwears that were acceptable by the Europeans, they were extremely gross, let's say, for some countries in Asia. And we had to, and we discovered that after some customers complained, and we had to have one specific model that would remove nudity or this kind of underwears for the European market and then also for the Asian market. And we had to also think about how can we actually label those products? How can we settle like a line or a boundary between those cultural aspects and ethical aspects of each region? So we had to hire people from a diversity of countries in Europe, a diversity of countries in Asia, to classify those, and we train models for each specific market. So now becoming like global companies becoming more and more aware of these cultural limitations and biases and so on, having guidelines such those proposed would potentially have mitigated these issues before we had the first complaint coming from the customers. So again, ethical concerns actually is becoming a new form of competitive advantage for companies. So if companies have really well-funded data collection, a well-funded data governance of maintenance of that, risk assessments end-to-end, it's also becoming actually like, as I said, competitive advantage for companies across the globe. I mean, we see Facebook when Cambridge Analytica issue came, they suffered harshly as a brand, and now other companies are also becoming aware of this risk and making sure that basically companies are clean and ethical as any company should actually behave. And I think that's it on my point. Thanks
Thank you very much. Thank you very much, Claudia. Actually, there is also, we have a lot of questions. I already shared 2 for our panelists. I will only share an additional one so that we then have a final wrap up with our speakers. So this one is more addressed, I think, to Miriam, but Laura, but anyone else will be very welcome to join in. This question is also by another Laura that is following us, and she's asking what would be the main differences between the risk-based approach of the proposed by the IA Act and the one proposed by the Brazilian Senate report. So I don't know who wants to start providing final remarks. We had several questions. I would like to ask you to keep your replies to maximum a couple of minutes because we are already running out of time, and I would like to keep only this final 5 or 6 minutes for final considerations. Andrea, please, the floor is yours.
I can start, but I don't want to ruin anybody else's plans. I'm very late for another meeting, so I'll try to go first. So do we need an AI authority in Brazil? That was one of the questions, right? I will take the general answer. I think it is very important to have a body in charge of overseeing the implementation and updating the state-of-the-art knowledge for the community of developers and for the entities having to comply with the overall framework. It's very important to have thereby a dedicated authority that is also a little bit of a hub and spoke, if we just in line with what I said before. So that it's an authority that centralizes information, has experts from the field, from academia as well, but also is able to relate to sector-specific regulators in a way that tailors to their needs the guidance on how to best comply. On the, I'll perhaps give an answer to the EU versus Brazil risk classification. Seems to me that it's not very different, but I'll see what Laura says. Meaning that in the EU there's this 4-tier classification, but the top 2 tiers are the ones that are really mostly invested by the regulatory requirements. One as a prohibition, and the other one as a menu of regulatory requirements. And it seems to me that Brazil does not define the no risk, which would be the residual category anyway, but defines the excessive risk and high risk, which might be broadly comparable to the unacceptably risky and the highly risky. But then, you know, subject to what Laura will say, she maybe has looked a little bit more into the 2 texts and can compare better. So I'll stop there, and I'm sorry I'll have to leave right away.
Thank you very much, Andrea. Please, Laura, the floor is yours.
Sorry, thank you very much for the questions, and thank you very much, Andrea. I think you answered in a way that I was going to address as well. So firstly, I think, and we understood that it's important to have this central governance authority, and we don't have to create another authority. We think that it could be indicated by the government, by the executive branch, but there is a need to empower a body to coordinate such and to have such important attributions and responsibilities that nobody has yet in the Brazilian landscape, institutional and legal landscape. So I think it's important to have a body like that. It doesn't have to be created. It can be designated, indicated, or something like that. And regarding the second question, I agree with Andrea. Yes, we have some very strong similarities. I would say that maybe one of the differences is that we have some general obligations and of course general rights as well, like basic rights that applies to all risk categories as long as the system impacts a person. So I would say that it's quite similar, but there is some differences regarding the some general obligations and some basic rights. That is, so I would like to thank you so much to participate, and thank you to exchange ideas with in such a high level event. Thank you so much.
Do we have any other comments or questions before we close today's meeting? I see no hand raised, so I would like to thank everyone for the very exciting presentations. There is really a lot of good ideas that are emerging from today's debates, and really there is material to start a lot of other new research initiatives, projects, and I'm sure this will not be the last webinar that we will have on this matter over the next years. I see this moment as particularly challenging, but also very fascinating, precisely because both EU and Brazil are crafting their responses to frame the best possible AI governance and regulatory tools. And so we are still in the historic moment where this is happening. We will have new occasions to discuss this and also to monitor the advancements of what we have been discussing today. So thank you very much to everyone. I would like now to give the floor to my friend Luigi for some final thoughts, and then we can call it a day.
No, Luca, thank you very much, and also to all the speakers, all the participants. As I said, I think it's important also the role of Fundación Getúlio Vargas, because we need to find a way to have more discussion, more exchange of view, and work together more closely, involve the industry, the university, and let's see whether there will be more mechanism of exchange, dialogue between Europe and Brazil in the field of digital, which we know, all of us, we know is extremely important. Thank you very much to everybody.
Thank you. Bye-bye.